Good morning, everyone. I'm Benjamin Sanchez, and welcome to the Sanchez Law Firm Second Saturday Series. Benjamin Sanchez, and welcome to the Sanchez Law Firm Second Saturday Series. Hold on while we get our technical stuff together. Well, it's a new year, a new look. Some of you can know me. You can see that I'm missing some facial hair. This is the way I look underneath the beard. Today's topic is Homeowners Association. We call it Homeowners Association, but legally, they're not called Homeowners Associations anymore. And we'll get into that. So Texas has what's called Property Owners Associations instead of homeowners, because we also have condominium owners associations. So Texas has done away with the jargon of HOAs and replaced it with POAs. Of course, that can sometimes get confusing because you may be thinking of a power of attorney as opposed to a property owners association. So we just leave it, we just call it HOAs just to make it simple, because that's what everybody recognizes them for. In today's 1 hour session, we're going to be having some questions at the end, questions and answers at the end. I kind of want to go over a little bit of the history of POAs in Texas, why they're here, what they're designed for, and then go over some of what they're statutorily designed to do, what powers they have, and then what happens generally in disputes and what kind of disputes that homeowners can face with HOAs. Part of our practice is real estate disputes, including HOA disputes. So we don't represent the associations. We only represent homeowners, condominium owners, and sometimes tenants when there are issues revolving HOAs. Those kind of issues really deal with the homeowners association and the homeowner fighting, but the tenant is sometimes the one who has to bear the brunt of that fight. So in Texas, we have a very strong property right for individual property owners. That's just the way Texas has been. We have lots of land, and we really pride ourselves in having ownership of land because we have so much of it. And we really generally try to have property owners have rights to do pretty much whatever they want with their land within reason. Obviously, if what their actions are affecting other people, then we have restraints on those, and that's why we have some laws. Some of those laws may involve issues such as noise, pollution, environmental runoff. Sometimes you can build things on your land that create issues on other land. So I've been in disputes where a homeowner or a developer has built a house next to another house, but they built the house up higher and they had a water runoff. So the water to the other next door neighbor would gather under their house, not because of anything that they did, but because of the new development that was next door that caused that water runoff to go into their property. So again, generally we have a strong property rights in Texas. Since about 1980, Texas has trended towards having these associations developed, and because of land restrictions. So although in the past we had 100% do whatever you want, over time we've decreased the amount of freedom that property owners have over their property. And as we decrease those freedoms, we have more restrictions, and then we have more government by the property associations. Generally, the power to determine what to do with your property has shifted, and now developers are starting to have these deed restrictions when they develop land and communities at the outset. So no longer do homeowners have full control over what they want to do with their property. If you move into development generally since 1980, there's probably going to be some sort of deed restrictions and some sort of land use restrictions that are governed by a homeowners association, again called a property owners association. Everything okay? Yes, sir. Now, generally in Texas, and in most places throughout the United States, whenever you have an agreement regarding real property, that agreement must be in writing. We here at Sanchez Law Firm do a lot of real estate disputes. And unfortunately, sometimes we have to inform clients who think that they have an agreement regarding land, that they really have no agreement at all because it was verbal and not written. This comes up a lot in the context of someone wanting to buy a home that's owner finance, and there's some sort of handshake, a verbal agreement, or there's a written agreement to start out with, and then an amendment or a change to that agreement that's verbal. And people think that that suffices, and it doesn't. So in Texas, in order for you to have deed restrictions, those deed restrictions must be in writing, or else they will not be enforceable. So you can buy some property, you can have someone tell you, oh, you can't do this, this, or this on your property, but unless it's in writing, it's not going to be enforceable. There are duties and requirements of homeowners who are selling their property or developers who are selling new homes to give you notice of the deed restrictions and of the presence of some sort of governing authority, POA, property owners association. If they don't, that does not mean that they're unenforceable as to you. It just means that you may have a claim of misrepresentation under the Texas Deceptive Trade Practices Act. You may have a claim of fraud or whatever, but simply because you didn't know about the deed restrictions at the time that you bought the house does not mean that you get to get away with not having to comply with those deed restrictions. So we're talking about misrepresentations because the deed restrictions, legally, it's called running with the land. So it doesn't matter what happens between people. The deed restrictions are basically part of the land. So when you sell the land that has deed restrictions, those deed restrictions are always attached to the land, whether or not the owner knows about it, whether or not the buyer knows about it. So be mindful of that. You should do your research. Any good title company that can give you a title search should be able to inform you if there is some sort of deed restrictions or whatever, because when you do a title search, you can go back and see the history of the title and those dedicatory instruments, the very beginning instruments that create the deed restrictions, that create the property owners association. Those must be filed of record in the real property records of the county where the property is located. So if you do your title search and you hire a title company to give you title insurance, if they fail to do that, again, you will still have to abide by those deed restrictions, but you may have a claim against the title company for not coming up with that. You may also have a claim against the seller for not disclosing the fact that you may have a deed restrictions. Do want to let you know that the enforcement of deed restrictions by the property owners associations are deemed to be considered reasonable. Now, that's just a presumption in the law. It doesn't mean that the POAs have unlimited authority and power to do whatever they want to try to enforce things. But it does mean that when they go to court, their actions will be presumed reasonable unless the homeowner can show why their actions were not reasonable. So the court can determine by a preponderance of the evidence that the exercise of the discretionary authority by the POA. So the POA has discretion and authority to act and to enforce the deeds restrictions. The courts say that you can show that discretionary authority, the use of that authority, was unreasonable in the given circumstance that you're creating, that you're disputing. Legally speaking, the words arbitrary, capricious, or discriminatory are words that could show that maybe the action was unreasonable. We have a case going on right now with one of our clients who was sued by a property owners association for failure to pay dues and fees and assessments. And our client's argument was that they did not want to pay those dues because they were not getting reciprocal services that were promised by the property owners association in relation to the documents. So in that particular circumstance, there was a lot of complaints about maintenance and upkeep of the common areas and also about security. So when we looked at the documents governing the deed restrictions and the property owners association, the association had promised that they would upkeep security and maintenance on the common areas, such as the parks, and that kind of stuff. So we ended up representing our client and countersuing the POA to allege that they had failed in their duties. And so that was not only an offense to the lack of payment, but it was an affirmative claim against the POA for that. So you really don't hear about that too much. Usually POAs just sue, they have discretion, they get their money. There's not much you can do it, but there are certain circumstances in which you can make a claim against the property owners association for their lack of diligence in keeping up their end of the bargain. So how do POAs generally work? There's usually a board, and that board is elected by the homeowners of that community. And you have officers who are then elected by the board. So you may have board members who obviously have multiple roles. You have a board member that's a president, a board member that's a secretary, and whatever. If you have a large enough POA, you may have a board member who's not also an officer, they're just a board member. Those board members are usually governed again by what we call the governing documents of a POA. And the governing documents will usually be called a declaration of covenants, conditions, and restrictions. Sometimes they're also known as a master deed. And there could be a certificate of formation for POA, as well as a set of rules and regulations governing the POA. And then you may have heard of documents called bylaws. So there are different types of documents. They don't all have the same name. When you're making a request for those documents, you can actually make a request as a homeowner of the POA for those documents, but you do have to do it a certain way. You have to meet the guidelines of not only those instruments, but also the Texas Property Code. The Texas Property Code is where you're going to look primarily for Texas law related to the Property Owners Association. Now, most people are familiar with the fact that a POA may have committees. The biggest or the most well-known committee Any POA is the architectural committee. They're usually the committee who you have to submit proposed changes to, and they get their approval in order to do those changes. And again, that goes against what Texas has traditionally held as homeowners' rights do what they want with their property. So typical circumstances could be that you have homes that have certain materials or colors. You have homes that need paint. You have homes that have certain landscape issues, whether it's mowing or edging or whatever. I've seen letters as petty as, hey, you need to trim your grass, so trim the sidewalk. So the grass was cut, but because the sidewalk wasn't trimmed and edged, the homeowner got a letter for that. And then if there are breaks in the sidewalk, sometimes you'll get a letter for that. I recently received a notice, from a client, but that client received a notice from an HOA saying, your sidewalk is too messed up, you need to replace it. And they're demanding that the homeowner replace it or within 30 days or come up with a plan to do so. But that also would be a violation. So you can imagine if you're, and sometimes that seems like it's an extreme. I think that some homeowners who live in very nice neighborhoods would argue that, hey, they want their entire neighborhood to look well. So, they don't want some home whose sidewalk is buckling up and breaking and not having a nice yard, and that somehow devaluing their property value. I think that a lot of times it comes down to these property value assessments, and homeowners really are trying to protect their values by agreeing to be in a POA community. And they hope that the enforcement of those property deed restrictions will keep the values of the property up. Again, prior to 1980, there were some POAs, but there were not a lot. But then when planned developments and communities like that started really happening in the 80s, there was a big push towards these deed restrictions. So if you go into an older neighborhood, you will, some would argue that you would see a difference in the way the community looks, the upkeep of the community, because it's older, there are no restrictions, and they may argue that those communities don't look as good as in some communities that have been popped up. I grew up in an older community. Personally, I like the natural feel of older communities and the natural trees and things like that. You go into a new community and, it's just different tastes with different people, but you have to know what you're getting into when you get into a new community that has those restrictions. The POAs do have to have an annual meeting. Most of the time they have a monthly or bi-monthly meeting as well. They can't get away with not being able to give the homeowners a way to address the board, to address problems within the community. And so they are required to have some meetings. Again, there's an annual meeting. There has to be directors. The directors also have to have certain qualifications. So you can't have someone who's not part of the community, not a homeowner in the community, to be on the board per se. So this really affects people who rent homes in property owner association governed communities. So if you are a tenant in a home that is subject to a POA, you as a tenant do not have the right to address problems with the board. That is your landlord, i.e. the homeowner, who has that responsibility and that right and that duty. So there could potentially be some sort of, I think, agreement. You could potentially have appearing by proxy, so the homeowner gives the tenant the authority to speak on behalf of the homeowner to address the board. A lot of times the POAs do not like that. They really want to hear from the homeowner, him or herself. So then you have to maybe as a tenant, you have to have some sort of agreement that the homeowner, as part of this lease, will address the board when things come up that need to be addressed. So a lot of times, if you look at the standard lease in Texas, it doesn't talk about POAs or what to do. So they're mainly designed for apartment associations. So you really have to make sure if you are a tenant in a home in such a community that you address that in the lease. Who will talk to the board? Will the homeowner be responsible for bringing certain things up to the board, the POA, or will he or she give that authority to the tenant to do so? The other law is that those board meetings must be open meetings. Now, they can go into private sessions, and they often do that sometimes, but the meetings themselves are designed to be open to the community, and they're not supposed to be some sort of secret chamber where they get to do things in private. So you as a homeowner can attend that meeting. The question is whether or not the tenant of a homeowner who's not actually on the agenda to speak, whether that tenant can then be a part of that community. Of that meeting. I would argue that they should be able to, but I've seen circumstances where the meetings are really limited to the actual homeowners in the community. So again, I think that's something that you would have to address maybe in the lease and maybe deal with that up front before the meeting takes place, instead of showing up and then making a scene to try to deal with that. There are some situations in which the board can meet without notice to the homeowners, but those are few and far between, mainly deal with emergencies and things like that. But there are the things that do require a board to give notice and have an open meeting. Could be things like assessing fines, damage assessments. They could initiation of foreclosure actions. Must be public initiation of enforcement actions, special assessments. There could be appeals from denial of an architectural review committee, the suspension of a right of an owner to speak and participate, lending and borrowing money, and other stuff. So there's just a myriad of other things that require open meetings in Texas by the board. Now, the homeowners also have a right to vote on certain things that must go before the board. The board has a right to vote. Primarily, these boards are the ones who do all of this. So you as a homeowner get to see things, but you really must, the actions are really done by the board. And so therefore, if you have a problem with the POA, as sometimes people do, they run for the board. There are some POAs that just have boards to stay on forever. And so you think that, well, I've got no control because this board of 4 or 5 people or whoever have been around for so long and they just keep being on the board. But there has to be elections. So there's not a permanently installed board. They have to announce elections, and you can run, you can get the support of the homeowners and try to get elected as a board member and try to make some changes within the board. Let's talk about some issues related to what homeowners typically see and kind of disputes that they typically deal with. The number one, obviously, is the assessments of the annual dues. Those annual dues are not statutorily governed. So you can't go to a statute and say, well, you're charging me too much because the statute says you can only do this. Obviously, the wealthier communities will have higher dues, and the And generally speaking, the poorer communities will have less dues. However, I've seen situations where poor HOA communities will increase their dues because they really want to increase the security and maintenance and other things. They have things that they want to do, and so they will raise the POA dues so that they have money to then spend on projects. So they can have general dues, but then we also have the issue of special assessments. Special assessments generally arise because there is a special project that needs to be taken on that can't necessarily be paid for by the annual dues that people give. That may usually involve some sort of repair to the community properties, whether it's things that a city or town government won't take care of. But there are special projects, whether it's building a new entrance to the community, establishing some sort of amenity like a pool, a pool house, a park, courts, basketball, tennis courts, and things like that. There are different things that a POA can ask for special assessments, and then those special assessments are generally they're one-time assessments, or they may be over time, but they're not part of the regular annual dues, and you're required to pay for that. Now, generally, these special assessments will have some sort of vote attached to them, and as long as they're passed, then you as a homeowner within the community are required to pay for the special assessment that's assessed against you. Even if you voted no, and even if you don't want that, whatever that special assessment is going to pay for, once it's assessed upon proper vote, then you are required as a homeowner to participate in that. And if you don't, that can get you into some trouble, that can get you into some fines and lead to all sorts of other things. So, you have to decide as a homeowner whether or not you really want to be involved in a community that potentially has the power to enforce restrictions to make the community nice to live in, but can also, quite frankly, be a living hell to some people because they're fighting with their POAs. The POA members and the board are abusing their authority and things like that. So sometimes you can get into a real mess. If you are a homeowner, you decide to live in it, you do have to pay those annual dues. You will have to pay for approved special assessments. You will have to go through architectural review committees with plans to do certain things on your property. I will just give you some firsthand experience. So my father lives in a community that has a POA, and POA said at one point my father was going through some tough times because of my stepmother's health, and so he didn't take care of the yard as much as he wanted to, and he got a letter from the POA stating that the branches to the trees were too close to the roofs of the garage in the house, and that basically part of the POA restrictions are that you can't have tree branches touching the roofs of buildings. And so when they sent that letter, we had to hire a special landscape person, tree trimmer, to actually go out and cut some of the branches so that they would not touch that. Now, I've had other cases where the community felt like a client's garage or house facing the streets were not painted well enough. So some of the paints were starting to come off or look rusty or whatever, and they didn't want that. So, they sent a letter saying you need to paint the house and in order to avoid any further fines. And quite frankly, they also have power to determine what kind of colors are available. So you go to a community that has a lot of white and beige and kind of neutral colors, they're not going to allow you to put some sort of bright green, or dark red or whatever, so they can enforce some of those colors as well. Now, beginning this year, this is something new. Beginning this year, POAs, which have the authority to authorize fines, they have to have now a written enforcement policy for that authority to levy fines, including they have to notice general categories regarding general categories of restrictive covenants for which the POA may assess fines. They have to have a schedule of fines for each category of violation, and they have to have information regarding hearings that are required under the Texas Property Code. Now, the enforcement policy may reserve the board's authority to levy a fine from the schedule on a case-by-case basis. But that policy must be posted on the Property Owners Association website or sent annually to each homeowner by email or mail or hand deliveries. So it used to be before 2024, you wouldn't necessarily know what kind of fines you were looking at. And you would think that between 1980 and 2023, at some point that would come up, that there should be some sort of notice to homeowners as to what kind of fines they could be subject to, how much those fines could be, and how they could dispute those fines at meetings. But quite frankly, it wasn't until January 1st, just last week, that you now have enforcement policies that are written down. So if your POA does not have a new enforcement policy that allows you to know what kind of categories of restrictions could have fines, what those fines are, and information about meetings to address those fines, you need to make sure to address that with the board. Quite frankly, most boards are, let's just say this, the general running of HOA boards and stuff have been now transferred to outside third-party property management companies. So these are POA association management companies that are hired to collect the dues, to address complaints and all that. And then those people may address certain things with the board. Now, the board still is obligated to have their meetings and do everything they're supposed to do under the Texas Property Code. But you as a homeowner are not really going to Mr. President or Mrs. Secretary to deal with those directly. If you want to schedule yourself to speak at a board meeting, that is done through the association management company, and those are the ones who are doing it. So really, it's the association management company that has been given that authority, delegated that authority from the board. So you're really dealing with that. If you have a problem with how the management company is running things, the association has a power to switch management companies. That does happen in Texas. I've seen that happen multiple times where a management company falls out of favor with a community and a board, and they will be replaced with another management company. Quite frankly, it's rare now that you see a POA that doesn't have some sort of outside management company connected with it, because they're not going to be the ones who are doing the actual collection and ledger and receipts and payments of money and all that. So they want to leave that to a third party, and that third party usually handles those issues. So when you're thinking of the board, just remember that the HOA Management Company Association, that company is not the association. That company is just a hired third-party company designed to do the administrative work so that the members of the POA board do not have to do that themselves. But the POA board still has to have that architectural committee. Those homeowners who are on the committee still have to do their work. The board still has to do its work. The officers still have to do their work. So they're handing off the administrative functions to the management company. Now, one of the issues with the management companies that I like to talk about with homeowners is that I think they have a quick trigger to fine you and to assess any kind of fees towards you. So anytime a management company has to do something that is not part of just collecting annual dues, they generally will assess a fine or at least a charge, a fee to your account. So let's say they have to send that letter that says the trees are hanging too close to your buildings. Well, guess what? Not only do you have to address that, but there's gonna be a charge in your account for them having to send that letter. Anytime a management company sends out a letter, they generally assess a fine. They charge you for the mailing costs, plus some sort of extra cost for having to send out the letter. If you're late, they send out these late notices. You will get some sort of late charge fee. And what I've often found with communities that have these management companies is that the fines and the fees and the charges often end up being more than the annual dues, because people just, they don't understand that those can build up. So I've seen cases where there's a $375 annual due, and yet my client comes to me and they now are thousands of dollars indebted to the POA, because the POA, let's say they didn't collect. But so for 2 years, if you didn't pay, that's $750, right? And if you didn't pay for 4 years, that's $1,500 in dues. But guess what? In all that time, they had to send you notices. More likely, you got a letter from an attorney saying, hey, you need to pay this. But when you look at their accounts, it's no longer $1,500. It may be $5,000 or $6,000 because of all that. And now the homeowners are stuck because they don't have that kind of money. They figured they had the money, they could pay the $1,500, but the HOAs don't consider that account to be in good standing simply because you now paid the dues. You're only in good standing when your account is zero and you paid all the fines and the charges in addition to the dues. So it's very important when you as a homeowner you need to realize that when you force these POAs through their management companies to do work, to send you reminders, to send you notices, that your account's going to build up very quickly. So it's the best that you either, obviously you try to keep up the deed restrictions for your particular home as much as possible. But it's also best to then, when you get these letters, to address whatever the problem is, not let it go, because as they have to continue to give you more notices, they continue to give you more fines. And so I've advised clients to immediately address the situation. And then we also have to determine from the management company, is there some sort of fine or fee associated with the letter that you send out, with the enforcement that you send out? Because you need to deal with that, because then they can get interest on outstanding fines and fees. Just to kind of go over that a little bit more, there is a priority of money that's received by homeowners, of how that's supposed to be accounted for by the POA. And the order in which that money is supposed to be applied, it first goes to any delinquent assessment, then it goes to any current assessment, then it goes to any reasonable attorney's fees or collection costs, and then it could go to other attorney's fees that are not subject to what we talked about before, plus any reasonable fines and any other reasonable amount that's owed to the POA. It does say, however, if at the time the POA receives a payment from a property owner, when the owner is in default under some sort of payment plan, the POA is not required to apply the payment in that order. In applying a payment, a fine assessed by the POA may not be given over any other amount owed to the POA. some people are concerned and have asked us about liens, HOA liens. So HOAs pretty much have a automatic lien on your property to enforce the payment. Now, it doesn't show up per se as a lien that you have to deal with at any time, but when you get behind, there is a foreclosure process by which an HOA can foreclose on your home in order to pay the assessments because of that lien right that they have. Unlike a bank, the HOA, just like a property tax government associate entity, they have to get a special order from the court that authorizes the sale of your home in order to pay for the money that is owed to the property association. So there is what we call a non-judicial foreclosure in Texas, which allows a bank who has a mortgage or some sort of loan with that property, they can do a foreclosure as long as they they go through a certain process, and they can do that foreclosure without having to go to court. However, taxing authorities and HOAs cannot do that. They must file a case in court and then eventually get a court order if they win that case that says that this is how much is owed to the POA, so they could determine the amount of damages and attorney's fees, interest and all that. And then the order also says that the POA has the authority to sell the property in order to collect on that. Now, if the POA happens to go through with that sale, which is usually conducted by a constable, then the what I call the surplus is supposed to be given to the homeowner when all the costs are already done. So there are going to be costs associated with having to sell the property, list the property or whatever. So once all the costs are done, if there's money left over from that HOA foreclosure sale, then that money should go to the homeowners, but the homeowners usually, they just don't give it to you. There's a big business starting where we've had a lot of foreclosures, and I've seen a rise in especially non-attorneys who want to help people gain the surplus funds that were there after a foreclosure sale. And so those people usually need some sort of attorney. I'm asked at least 2 or 3 times a year by non-attorneys if I will help them get surplus funds for homeowners. I generally don't like to do that because I just think that these companies that are doing it, they're obviously getting some sort of funds from it. They're not doing it for free, okay? And so, there's arguments both ways because a lot of homeowners don't know that they have the right to get surplus funds. They may not know that they have surplus funds to begin with. And so if that money stays with the court, so generally that money is turned over to the court, it will then be given to the state comptroller's office as funds that are not collected, and eventually, if it goes on long enough, the state can use those funds and you lose access to those funds forever. So I do get the benefit of informing people that there may be surplus funds or whatever. To me, I'd rather do the education like we're doing today, so that you have that right and to look for those surplus funds. But some people just, they will want someone else to handle it for a fee. And as long as you understand that, then that's fine. The reason why these non-attorneys need attorneys is because the way that works is the attorney is the one that can represent people in court. And so we have to file a motion to release the surplus funds from the court registry. So a non-attorney can't do that. Remember, in terms of legal representation, a business that's incorporated or somehow just a legal entity, they have to have an attorney in courts in Texas. And then for individuals, you can either represent yourself or you can have an attorney. But generally speaking, in county and district courts in Texas, if you don't know what you're doing, you need to hire an attorney, but you can't hire some third-party non-attorney who says they can get you surplus funds to then go to court for you because they are going to be looking for an attorney. So whether or not, the attorney's going to charge no matter what, right? So if you use these people, you understand that they're going to be charging a fee, the attorney is going to be charging a fee, and both of those fees will then come out of the surplus funds before you get it. If you didn't know that you had surplus funds, you don't want to deal with it, that may be fine, and you may be acceptable of that arrangement. Otherwise, it'd be best just to go directly to an attorney who can do that for you, and at least that's one less fee they could be paying someone to get those surplus funds. Here. There's so much in property association issues and taxes that this is not meant to be a really deep dive. But I do want to let you know that you are not powerless as a homeowner when it comes to a POA. So the best thing to do is if you feel like you are not being treated fairly or legally, then it's best to see an attorney. There are attorneys that do this. Again, our law firm handles consumer law and real estate disputes. Real estate disputes involve everything from HOA disputes, buyer-seller disputes. There's a lot of contract for deeds in Texas. We do that. Landlord-tenant. What we don't do is we don't create, leases and things like that. We will create deeds because those are fairly simple in Texas as long as you know what you're doing. I wouldn't suggest that a person do it without an attorney, just because if you screw that up, that can have some consequences later on down the line. Another thing you should understand is that most POAs have some sort of insurance policy to cover the actions of the board members and the officers. It's usually called a E&O policy, executives and officers policies. And so if you potentially have a legal claim against the board or the POA, that POA is then going to turn that over to some sort of insurance company. And that insurance company then has a duty to defend the POA in that claim. So they'll hire an attorney to then reach out to the claimant and kind of go from there. Earlier, I told you about this one set of clients who, so they had a claim against them because of failure to pay dues over several years. And that eventually became a legal court case where the POA filed. They have their quote regular attorney that kind of does the enforcement and collections when they have to go that far. And so that attorney filed a lawsuit against my clients. My clients started that lawsuit pro se, meaning they were not represented. They quickly understood, I don't say they quickly, but eventually they understood that they were dealing with an attorney on the other side who knew what she was doing, and they better hire an attorney. And so they eventually came to our firm and hired us. One of the things that we saw in our assessment of the situation is that the reason why there was a lack of payment of dues is because they were fighting the fact that the POA was not honoring their obligations under the governing document. So they were lacking in common area maintenance. They were lacking in security. And in fact, some of their, so for example, you have fences with these big easements where utilities like electrical poles and all that. And some of the tractors that the lawn people are using were bumping up into these wooden fences and actually causing damage, right? So not only were they not getting the services, but the POA through their agents were actually damaging property through how they were handling lawn care and all that. So we decided that not just being defensive, because I believe that a good offense is a good defense. And so we then turned around and sued the POA for all that stuff. Well, what happens is that POA, the attorney who does the collections is not the attorney who's going to defend those. So that POA then turned over the claim, the counterclaim, to their insurance company. The insurance company then hired separate counsel, because they usually have their own counsel they have to deal with, to then defend against the counterclaim. Then at that point, our firm was fighting two sets of attorneys. We had the collection enforcement attorney on one side, and we had the insurance defense counsel defending against the counterclaim on the other side. So that can happen. And I think the last thing I want to say is a lot of these instruments, these governing documents will now say, because it's a big thing, is that for any claim that you have against the POA, that has to go to arbitration. The arbitration clause does not usually apply to just the simple enforcement of dues and collection costs and all that kind of stuff. But they will say in the arbitration clause, if you have a claim against us, you have to go to arbitration. So in that lawsuit in which we filed the counterclaim, eventually the insurance counsel filed a motion to compel arbitration that ultimately was granted. So then we had to move the entire case, not just the counterclaim, but also the original claim, the entire case, then had to move to arbitration. I think that's what I want to cover, but I know we have some questions. So let's see. Do we have any questions?
If a raise in dues are voted on in November, due at the end of December, but not recorded on county records till the following July, can the board actually charge you what was voted on in November prior to it being recorded?
So the question that we have here is if you have dues that are voted on and approved, a raise in dues that are voted on and approved in 1 month, but not recorded for 6 or 7 months later, can those still be required, basically? The question should be one of notice, right? So there is the issue of having to file the, the changes, but is there notice to the homeowners? I think the argument in court is going to be that if there was notice given to the homeowners, despite the fact that the dues were not put into the property records, the homeowners are still going to be required to do that. Now, if there was some sort of open meeting in which those raise and dues were approved, but then after that, there was no notice. Usually there's notice given to every homeowner of things like that. If that notice was not sent out, then I would say that you're not required to pay those dues because you have to have notice. So it's not just about recording, it's also about notice. And I think if there's notice, the recording later can be okay as long as there's a proper notice. Anything else? Well, that concludes our seminar. I want to talk to you about our upcoming seminars. And just to give you, I really want, since we're in a new year, I want to let people know we really are committed to the second Saturday series. We've done it for a few months in 2023. We're thinking about some way to have some sort of a certificate for those who attend everything, because we sort of think of this like as a Texas consumer law school in a way for consumers. We're really trying to educate you. Again, we sort of give you the highlights, but if you need specifics regarding your case, you really should do a consultation with us. But our next seminar is going to be next second Saturday, which is February 10th. And that's going to be on mastering the art of mitigating damages. And just to kind of give you a brief preview, it is required in law, especially in the United States, is that when you are damaged, you as the victim still have a duty to minimize the damages. Okay, so that can take a lot of different forms, but if you have, let's say, a plumbing leak, okay, in your home that you rent, and you call the landlord and something's just not going right, you should be calling the plumber to try to fix it, to minimize the damages. You cannot just let damages pile up. If you take a car to a mechanic and the mechanic is taking too long and then threatens to have storage fees, you shouldn't just let it sit there, right? You need to go ahead and get that car out to minimize the storage fee, the claim you may have. So we'll talk in more detail about the rule that you must mitigate damages when something bad happens to you and you have a legal claim. And then in March, we're going to have a seminar on door-to-door sales. There's a law called the Texas Home Solicitation Act that deals with door-to-door sales. And so we're going to go over the scams and give you the knowledge to empower you on how to deal with these people and what happens, what your rights are when you fall victim to them. The most important thing, I can tell you as a preview, is a 3-day rule, but many people misunderstand what the 3-day rule is. So when you tune in March, we will go over this 3-day rule and what you can do about it. This is really important, for example, in claims where the product or service is not going to be delivered right away. So you buy something, you buy a vacuum cleaner from someone or a set of encyclopedias like they did in the old days or someone right on the spot. That's one thing. But normally in this day and age, you're buying something but not actually seeing the product or the service until after those 3 days. So we'll discuss the issues regarding that. If you have any questions or want any additional information regarding your particular situation, we have people here to help. We are a strong consumer and real estate law team. We have 14 people on our team. Most attorneys just have themselves and maybe an assistant who does everything else. So we have the wherewithal to fight the companies, the POA companies and other creditors and everybody else. Our phone number is 713-780-7745. Again, that's 713-780-7745. And our website is www.sanchezlawfirm.com. All one word, so www.sanchezlawfirm.com. We look forward to hearing from you. We know that when you come to an attorney, usually you're not in the best situation, or else you wouldn't need the attorney. But when you come to us, we hope to make your experience the best possible because, as always, we are excellence in action. Thank you.